Good morning, everybody. You don't applaud. You don't know what I'm going to say yet. You can applaud after if you like what I say. Thank you for coming. I know that I'm competing with the keynotes on the South Stage, so I'm very impressed that you guys decided to come here instead. I hope it's worth your while. I'm going to do my best to save time for questions, so I may end up speeding through certain parts of the presentation that are less interesting in order to give you time for questions. But if anybody has a question about something, obviously don't hesitate to ask, and even after the session, of course, feel free to approach me to ask. We can skip the disclaimer. Okay, so what we're going to do is we're going to have our dessert, and then we're going to have our vegetables. So what I mean by that is, first we're going to talk about stuff that I really like to talk about, which is sort of big picture questions about how we should be thinking about AI and how that should inform policy and law around AI. And then we'll talk about what the actual laws and bills that have been proposed are attempting to do and some of the enforcement actions. And then at the end, we'll talk about what you should do in the meantime, because everything is dynamic and ferment. In fact, just yesterday, there was an announcement from the federal government that made me have to change one of my slides. So I frantically emailed the revised deck last night saying, can you please use this instead? And they were able to. So things change. What I tell you today will not be true a month from now. Hopefully a lot of it will be, but certainly around the details it won't be. Okay. So first, what is AI? I really love this quote by Ryan Calo at UW School of Law, where he says, it isn't a thing like a train, right? It's a set of techniques. And so what that means is, I think, is if you agree with Calo on that, that says something about how we should be thinking about how we regulate it. We should not regulate it, Calo would posit, like we regulate railroads or other specific discrete things, but should be thinking about it somewhat differently, not as a industry sector, but as he says, a set of techniques. So we'll keep that in mind as we progress. This is just some interesting historical trivia. The term was first coined, artificial intelligence, in 1956. And my partner, Mark Davies, has a book, AI Litigation. And in that book, he found this great case, which is cited up there, that involved apparently a pseudonymous blog poster who was posting about a company named Spider Labs. I don't know if that company still exists, and if it does, I don't know if anybody here is from Spider Labs. I take no position on what I'm about to say. But the blog poster contended that Spider's statements that it used AI in its product suite were false, that it wasn't AI. And so Spider wanted to sue this guy for defamation, it's person, I don't know, for defamation. And because the blog poster was pseudonymous, the company had to issue subpoenas to Google and to LinkedIn to try to get the name, and so the court adjudicated that. And what the court said was, it quashed the subpoena and said, it doesn't matter who the person is, because this statement, by definition, cannot be defamatory, because nobody knows what artificial intelligence means. So you cannot possibly prove that the blog poster was speaking falsely, because we're never going to agree on what the term means. So I thought that was kind of interesting. Now, as a general matter, when people talk about AI, they do tend to segment AI into two broad buckets, general AI and narrow AI. General AI is what we think about in the movies, and it's going to be, I think, no longer notional as indicated there soon, but the idea of an intelligence that exhibits a behavior at least as advanced as a person across the board, right? So you wouldn't be able to tell this is not a person if you were talking to them, the famous Turing test, but on steroids, right? That's general AI. Narrow AI, which we're seeing lots of already, is an AI system that addresses specific application areas, such as playing games. In addition, of course, the rage today, and we'll be talking about this a lot more over the course of the next 40 minutes or so, is generative AI. AI that can generate novel content from existing data sets. It's an interesting question as to whether generative AI must be general or narrow. One of my partners the other day and I were debating that in the context of chess AIs. And so we asked ChatGPT what it thought. And perhaps somewhat snobbishly, ChatGPT said that chess AIs are not general AIs because they're only designed for gameplay. Not generative AIs, excuse me, because they're only designed for gameplay. So that's ChatGPT's opinion. I don't know. I think it's an interesting question. Okay. Legislatively, legislators have struggled with the definition of artificial intelligence as well. The Algorithmic Accountability Act of last year, which did not pass Congress, sets out, I think, a pretty straightforward, easy to understand, and broad definition that focuses on the use of computation to generate a basis for a decision or judgment. It's a very broad term, right? Encompass all kinds of machine learning, for example. The European proposed AI Act, which remains proposed, but will be finalized at some point in the near future, has a much typically European longer definition of AI. But I actually think if you read it through, and I'm not going to read it through to you, amounts to much the same thing. It's a more exhaustive way of saying it, which is, again, I don't intend any offense to Europeans, but it's often emblematic of European legislation. So what should the standard be when we're thinking about regulating AI? How should we think about the risks and the benefits? Should AI be held to a standard of perfection? Should it be held to a standard that is better than us? Or is it enough that it's equal to us? Right? This is really a fundamental question that underlines a lot of policymakers' thinking around AI. And I think it's one that has significant ramifications. And we'll talk about this, or think about this as we talk about what is being proposed. And you can tell, by the way, from my illustration where I come out on that. The classic way of thinking about that question, it's a little dated now even because we've gotten so much past the idea of autonomous vehicles, even though they don't really quite exist yet. We're thinking about so many different and new concepts of AI that autonomous vehicles seems almost prosaic. Nonetheless, I think it's a great way of thinking about this problem. For those of you familiar with MIT Moral Machine, I always talk about it because I think it's such a great exercise. MIT Moral Machine is a site run by MIT where they will present to you various scenarios. It's the trolley car problem, various scenarios of an automobile, a self-driving automobile that is speeding down the road and will hit certain numbers of individuals if it does nothing, and some other ramification, killing, for example, the passengers in the vehicle, or perhaps killing people somewhere else if it makes a turnoff to avoid the people in front of it. And it runs through variations of the scenarios. So in each scenario, there'll be a different number of people. In some scenarios, the people might be elderly. In some others, they might be children. And they might be scientists. They might be convicts. There might be dogs and cats and babies, all kinds of different variations. And they ask you what you would do. And it's interesting because the site used to then post the results on a geographic basis. For some reason, they're not doing that anymore. I don't know why. At least I couldn't find it. But I always found it fascinating because you would see that different countries came to different results. Some countries privileged children more. Some countries privileged elderly more. Some privileged animals more. It was a fascinating exercise, and it really goes to the question of, if we can't agree, how do we expect AI to make that determination? I don't know about you, but certainly when I'm driving a car, I would not go through that careful calculation, how many people are here, how many people are in the car. I'm actually embarrassed to think that I probably would do whatever I thought would maximize my own chance of survival, right? But the question is, what do we want AI to do, and how do we want it to accomplish it? And that's, the car scenario really frames that starkly because of the immediacy of the consequence. Of course, it's not just cars. There's all kinds of additional types of implementations of AI where this kind of question comes into play. And what's interesting, I love this poll. I don't love it, but I thought it was great that it came out shortly before this conference because I thought it would be great to present to you. Monmouth University did a poll on the impact of AI as society. Now, all polls are subject to manipulation. You have to look at the questions. So, I'm not presenting this as a definitive snapshot of society's views toward AI, American society's views toward AI. But nonetheless, Monmouth is a reputable poller, and this is an interesting set of data. Asked what people anticipated the impact of AI would be on society. And you can see from the colors here that the vast majority of people think that it will either do more harm than good, or just have neutral impact. Very few people in purple believe it will be cause more good than harm, which is fascinating when you think about that, at least to me. And breaking that number down a little bit more, 73% believe AI will make jobs less available and harm the economy. And I should note that they're in good company there. Nouriel Roubini, who's a well-known economist, sometimes known as Dr. Doom, he wrote a book called Mega Threats recently, which I really made the mistake of reading on vacation. It's kind of a downer for a vacation book. And in that book, he identifies a series of mega threats that he sees on the horizon. One of them is AI. Now, I differ with that. I'm a technology optimist, and we'll talk more about that. But that, those 73% are certainly in sync with Roubini on this question. 56% believe it will harm the overall quality of life. 55% worry that it one day may threaten our very existence. It's crazy. I mean, it's amazing that these are the numbers, the way that people are thinking about AI, right? These kinds of numbers guarantee some type of governmental response, right? If politicians believe that their public is worried about AI, they will do something to respond to AI. 55% favor the concept of a federal AI regulatory agency. In other words, railroads, right? We have, just like we have an agency to regulate railroads, I forget what it's called actually, whatever, it doesn't matter. We want an agency to regulate AI, right? Which is very different than the way Kalo is thinking about AI. Now, what the poll didn't do, or at least the report that I read didn't say, is does that break down differently by political affiliation? I don't know if Republicans and Democrats both would have answered that question the same way, I have no idea. But that's a large number of people that are saying we need some kind of regulatory agency to regulate. Some more data from the poll. It's interesting, if you look, there are some jobs that people are happy to have AI perform, like coal mining, right? And others where they really don't, like robotic nurses. They don't like the idea of robotic nurses. And so it's trying to just figure out, like, what is the difference? I'd had a couple of ideas, you know, and it's hard to glean anything definitive from one poll, but it seems as though distance from people, passive types of tasks rather than active ones seem to be more palatable to people than things that are more interactive, in your face, and active. Okay, so what are the risks that people worry about or should be worrying about when it comes to AI? So I'm going to, at a high level, talk about a few of them. Intellectual property risks. This is really specific, in particular, an issue when dealing with generative AI, but it can really apply in all categories of AI. Do you own the output of the AI that you're using? If you're using an AI to help you code, for example, right? Do you own that code? You can't copyright code that's been created entirely by an AI. The Copyright Office won't allow it. It's also, on the patent perspective, you can't have an AI as an inventor on a patent. So you got to think about, okay, well, what do I care? Is this important? It's something you need to think about. Also, you've got infringement questions, right? To what degree do you have liability for infringing another person's IP if the AI used or learned from that person's IP? These are unresolved questions that you need to think about when you're trying to use AI for this kind of purpose. Incorrect or misinformation. Now, this is not a new problem. Anne of Cleves is the portrait on the right, for those of you wondering. She was the fourth wife, very briefly, of Henry VIII. He was famously misled as to her appearance by an artist who was being very kind. And once she arrived and he saw her in person, he quickly gave her a divorce. The middle is me, but it's not really me. I wish I had a jawline like that, but if you'd seen that and you saw me, you'd be quite disappointed, right? So that kind of incorrect information is obviously a problem. And on a more serious note, the President Biden picture there is represents a speech he gave. I was going to play the video, but I decided not to, where someone altered the speech to interject people saying F Joe Biden during the speech. Didn't happen. It was altered, right? But people didn't realize that it was liked thousands of times or maybe even millions of times before, people said, wait a minute, this didn't actually happen. So obviously there are serious risks of incorrect or misinformation with AI. Data protection risks. What kind of data, firstly, is being used by the AI? Is it being used in compliance with data protection laws? And then what's the output? And does the output contain protected data? Is an issue that comes up in AI. And of course, risks of bias and discrimination. You'll see some examples that I listed there. There's a famous one from several years ago, I think 2016 or 2017, where in Sweden, soap dispensers wouldn't work with non-white hands. They wouldn't recognize the hand. That wasn't an intentional decision by the soap dispenser developers. It was because they trained the system on white hands, right? So it doesn't have to be intentional and still can result in bias. Soap dispensers are not high stakes, but many of the functions that we're thinking about for AI are much higher stakes than that. And Timnit Gebru at the DARE Institute has done a tremendous amount of work on the risks of bias and discrimination in AI, and she's shown through multiple data sets that imaging AI often works better on white subjects than on others. So it's just another example of the kinds of risks there that we're dealing with. The FTC, the Federal Trade Commission, which I'll talk more about as we get to regulatory action, has summarized a lot of these risks in a recent blog post talking about generative AI, asking, should we even be making it or selling it? Which I think is where we're seeing a lot of regulatory movement, like not how do we mitigate risks for something that could be very useful for society, but wait a minute, should we even be doing this? Which I happen to think is problematic, but I think is not difficult to understand when you think about all these uncertainties. On the flip side, the other side of the coin, Orly Lobel, a professor at the University of San Diego Law School, wrote this wonderful white paper earlier this year, which I highly recommend to everyone, called The Law of AI for Good. And in that, she says, look, we definitely have risks with AI that we need to manage. It's very important that we do that, but we have to also keep in mind that AI can do a lot of good things too. And she gave several examples. I just pulled out a couple here. AlphaFold, which predicted nearly all of the 200 million known proteins. I also read an article recently that there's AI that now is being used to design new proteins to help cure diseases. A study of OSHA, OSHA is the Occupational Safety Health Administration, targeting, concluded that that OSHA's job is to help ensure safe workplaces, but they of course are limited by their staff and their resources. They concluded that AI could have enabled avoidance of over twice as many injuries by helping them better target workplaces to inspect, which would have saved over $1 billion in social value over the decade reviewed. So it's important, as we balance risk, that we also keep in mind potential benefit. And so what Professor Lobel says is there are certain rights that she would like to see enshrined in policy here. A right to automated decision-making, not simply a right to be protected from it. A right to data collection to help improve AI, not simply a right to limit data collection. And a proactive AI policy that looks at these issues like public bias and addresses them. In her case, she's suggesting bounties. She talks about how humans can be biased against AI because they have an inherent aversion to algorithms, to things that are difficult to understand. Most people are not mathematical, I'm not mathematical, and have difficulty or discomfort, I should say, with that kind of approach. And I actually think there's also a natural risk of, preference for inaction rather than action. So in other words, people devalue risk of inaction versus risk of action. It just seems safer, right, to not do something than to do it. That's certainly my personality, and I think that's true among a lot of people, and I think that also impacts the AI debate. Okay, and here's what I say, are we overrating risk? Is there a bias toward inaction, a bias toward human discretion, which as we know has its own multiple flaws, and a bias toward privacy as opposed to some of the uses of data collection that AI can entertain? So what works best? Kartik Hasanagar of Wharton School of Business had published a paper not too long ago on researching AI-human interactions. And one thing that he noted, which I thought was really interesting, was that AIs know when to delegate, humans often don't, which points to perhaps a modus operandi for how we should be thinking about AI and the nature of human-AI interaction. Okay, so now the vegetables a little bit. We're going to talk about what are the legal frameworks that are in existence. Now, I will say first that most legislation, actually all federal legislation that has passed, which I'm not going to spend time on, last year I went through a bunch of it, is irrelevant to this conversation because all it does is promote AI development and research in an effort to ensure that the United States doesn't fall behind foreign powers, most prominently China. And so it's all about national security and funding and that kind of thing, not really relevant to the discussion of policy questions. But that's really all that the Congress has legislated to date. But on the executive side, we have seen some activity. We have the Office of Science and Technology Policy, which released in October principles for use of AI, which are laid out there, and they're consistent with what we've been describing so far. There's a National AI Initiative, which goes to the competitiveness side. The White House has issued statements, this is one of their AI blueprint, where they talk about how automated data systems can threaten the rights of the American public. They can be unsafe, ineffective, or biased. And what's really interesting about this language, and you'll see it even more as we go through, is there's a really heavy emphasis on risk. Again, if you have 55% of the public wanting to regulate, right, and 56% I think it was, or 53%, who worry that it might eradicate humanity, it's not surprising to see that government reflect that, right, through language that heavily weights risk. What kind of executive action have we seen? The Federal Trade Commission has been by far the most active agency in the space. They articulated last year several core principles. Start with the right foundation, watch for discriminatory outcomes, transparency, avoid exaggeration, tell the truth about how you use data, do more good than harm, hold yourself accountable. Nobody can disagree with those principles. I mean, does anybody disagree with those principles? Those are like principles for life, not just for AI, right? And that's the FTC articulating that, hey, look, just because we have this new technology doesn't mean the same rules don't apply. They do. But then the FTC's gone beyond that. Two really interesting settlements that I think point the way toward how the agency will be enforcing these issues in the world of AI. In January 2021, there was a photo app developer named Album, and the app was called Ever. The app developer misrepresented whether the app would use facial recognition. It basically said that it wouldn't use facial recognition, except if you were a user in Illinois, Washington, Texas, or the EU, where they actually told you, hey, if you, in those jurisdictions it required you to opt in before it used facial recognition. In other jurisdictions it did not, which is interesting. Why those 4 jurisdictions? Anybody want to take a guess? Those 4 jurisdictions have biometric privacy laws, right? Or the EU's got very rigorous privacy laws generally, and those 3 states have biometric privacy laws that require opt-in before you use facial recognition. So they built the app to comply with those laws, but in other jurisdictions they didn't say anything, right? And so, I mean, affirmatively did the opposite. They said, they misrepresented, saying you would not be subject to facial recognition. And so the FTC said that was false and misleading, unfair trade practice, which it was, and the company settled. And what's interesting about the settlement is not only did it require deletion of all the photos that were obtained without consent, it also required deletion of affected work product, which included models or algorithms that were developed in whole or in part using those images, which is amazing when you think about it, right? Think about that remedy. That's a very dramatic remedy. It required them to undo all of the work unless they could show that it in no way incorporated the unlawfully obtained data. The FTC did the same thing in another enforcement action in March of last year involving what used to be called Weight Watchers International. They have a Kurbo healthy eating app that was targeted toward kids and didn't comply with the Children's Online Privacy Protection Act. And as a result, they ended up settling, paying a $1.5 million penalty. But again, more importantly for us, had to destroy any algorithm that was developed using the children's unlawfully obtained data. A very powerful tool for the agency. It's not just the FTC. You see there HUD, the CFPB, which is the Consumer Financial Protection Bureau, federal financial regulators, all have taken steps or indicated an intention to take steps to address perceived harms resulting from AI. HUD in the context of tenant screening, CFPB in the context of consumer financial services, and so forth. So all the agencies now are really, the federal agencies are starting to get involved to address the perceived risks presented by the use of AI. Here, just another example, HUD and the Department of Justice intervening in a housing discrimination case, which challenged a tenant screening system on the basis that it was discriminatory. And you see, again, the statement that tenant screening policies are not exempt from the Fair Housing Act just because decisions are made by algorithm. So what's the underlying point? These laws apply regardless of whether you're using AI or not. Using AI is not a way to escape application of those laws, right? Which is very sensible when you think about it, right? And it's very different from the railroad approach, right? They're not saying it's the railroad. They're saying we're applying the same rules here that we apply elsewhere. Hot off the presses, this is the slide I had to insert last night. Just yesterday, the FTC, the CFPB, the EEOC, this is Washington, so all acronyms, the Equal Employment Opportunity Commission, and the DOJ Civil Rights Division issued a joint statement. It said nothing new, really. It basically reminded the public that their enforcement authority applies to AI, and again, all the rules that apply outside of AI apply on AI too. But what's really interesting to me about it is there's nothing positive about AI in that whole statement. Even where they talk about the supposed benefits of AI, which I quoted there, this is really it, I think, in the whole statement. They say AI is often advertised as providing insights and breakthroughs, et cetera. Not even sort of conceding that it actually has benefits. It's just an underlying skepticism that I think is where the government is right now. There's even a reluctance to acknowledge, this is a joint statement. It's not a formal action. It's a 3-page statement, and they couldn't even say anything positive about AI without saying it skeptically. NIST has been very involved in helping to think about AI. They published last year a report looking at bias in AI, and they identified 3 sources of bias: systemic bias resulting from existing institutions and societal prejudices, computational and statistical bias, data sets that are not representative, also the idea that somehow quantitative solutions are the best, what they call techno-solutionism. I can't remember if the report mentions this or if it just occurred to me when I was reading the report, but Ken Burns, the documentary filmmaker, coined a term called the McNamara fallacy. Is anybody familiar with that? The idea that when you can't measure what's important, you make important what you can measure. Right? And so the NIST points out that that's a problem, right? Because you can easily fall into the trap of thinking, well, because it's numbers, it actually is more reliable. And human bias, right? Humans are developing these systems. We all have our own biases. And so it's important to take that into account when thinking about how to deal with bias in the AI context. What the risk management framework that NIST produced, it's still in draft, as a result of thinking about those biases, is a system that's designed to help manage those risks. And it's got 4 key elements. Governance, a culture of risk management, mapping, understanding the context in which AI is going to be used, measuring, identifying the risks and quantifying them, and management, prioritizing and acting on those risks to minimize the perceived dangers. Pretty, again, straightforward. This is very, for those of you who are in the data privacy field, very similar to how NIST approaches privacy risk management, not surprisingly. But a useful tool in terms of an analytical framework for thinking about AI. So what about legislation? I mentioned before, at the federal level, there's been nothing enacted. The Algorithmic Accountability Act didn't pass. It would have subjected companies to the FTC authority and required them to assess the impacts of automated critical decision making, to do, in effect, like an AI risk assessment, similar again to the data privacy world. But it didn't pass. We'll see if it passes. We'll see if it's reintroduced and passed in this session. Other federal legislative action, this is just to show you what we're looking at, not substantive. Ted Lieu from California introduced a resolution on AI that was authored by AI. Cute. You see it right there, nothing substantive. And another representative from Massachusetts used ChatGPT to write a speech that he gave on the House floor. That's the extent of our, right now, congressional action on AI. At the state level, there have been lots of bills. Few have passed. Where we have seen legislation really has been in Illinois, dealing with AI video interviews, requiring consent to use AI in job applicant interviews. If you rely solely on AI, then you have to generate a report on the results from a race and ethnicity perspective. It's interesting, there was a report that came out, I think again yesterday, or maybe it was the day before yesterday, by Pew, that surveyed Americans' views of the use of AI in job interviews and hiring. And interestingly, unlike the Monmouth poll, there was a more positive view in some ways toward the use of AI. The respondents seemed to think that it would help weed out bias. So you see conflicting poll results. New York City, as of January of this year, has a law that restricts employers from using AI in hiring and promotion decisions unless you subject the system to a bias audit at least once a year. So unclear what a bias audit will involve or how that requirement will unfold. But that's really it. A bunch of states have created commissions or task forces, but nobody else, at least last time I checked, has passed a law as of yet. Okay, EU. We'll talk about the EU briefly. I mentioned it before. The EU has the AI Act. The AI Act has not been adopted yet. There's a lengthy process. I was talking to one of my European partners the other day, and I don't quite understand the process. There are a whole bunch of different entities that need to make decisions. Right now, the EU Parliament is in the process of coming up with its draft, and then they're going to try to harmonize the various drafts. But the basic framework is laid out. There are certain AI uses that are outright prohibited. There are then what they call high-risk AI systems, subject to more onerous restriction. And then there are limited risk and minimal risk systems. The compliance with this act, once it is enacted, will be subject to an EU AI board and national supervisory authorities, very similar to data protection authorities in the approach to data privacy. And much like GDPR, fines will be up to 6% of global revenue, which is quite significant. So what are prohibited uses of AI? Subliminal techniques to distort behavior are outright prohibited under the Act. Targeting human vulnerabilities is prohibited. What's most interesting to me is social scoring is prohibited. Social scoring is the idea that you use AI to assign for example, what reports have said the Chinese government is doing social citizenship scores to its citizens, right, to assess their behavior. Are you polite? Do you hold the door open? Do you vote? How do you vote, perhaps? All those kinds of things, and then assign privileges based on the score. So that's considered a prohibited use in Europe. And real-time remote biometrics in public spaces for law enforcement, unless strictly necessary, which seems to me to be a probably what law enforcement will say. It's always strictly necessary. But nonetheless, that's identified as a prohibited use. High-risk systems is a very broad category. Most systems that are interesting will be considered high risk. Biometrics, public assistance, critical infrastructure, law enforcement, educational access, work-related decisions, and so forth. If you are a high-risk system, you have an obligation to have an ongoing risk management program. You have to have data quality controls and governance over data that's used in the AI, record keeping and transparency, human oversight, accuracy, and registration of your systems. I'm going to talk more about this when I talk about some practical steps that I think you should take. But you can see sort of the framework that they're evolving around these high-risk systems. Right now, the biggest topic, apparently, that's under consideration is whether to include another category of AI, which they call foundation models. Bonus points if anybody recognizes that picture at the top of the slide. Anybody recognize it? Nope? Isaac Asimov Foundation, Galactic Empire. I don't know. No relevance, but the word foundation. I'm a big Asimov fan. Anyway, so foundation model is a model that is trained on broad data at scale, is designed for generality of output, and can be adapted to a wide range of distinctive tasks. It's intended to capture generative AI. And the idea is that generative AI might not be regarded as a high-risk system under the existing definitions in the Draft Act, but at least some policymakers believe it warrants higher levels of control because of the harms that it can cause, because it can be used in a wide range of contexts. And so they're proposing this intermediate designation foundation model. No idea whether it will be adopted. Originally, I think the Parliament was supposed to report out the bill, the act, or the bill, whatever, the version of the act tomorrow, but I'm told that was pushed back, so we'll have to wait and see. So now what? This is my plug, my annual plug for my daughter's Instagram. She's an artist. That's one of her pieces of art. So now what? Okay. I think, what should you do? There are 4 pillars of AI governance I think people should think about. This is not in a law anywhere, right? Because we have, as I mentioned multiple times already, no federal law and almost no state law, right? But it's designed to provide a workable framework for how we should think about AI, because none of us can wait for there to be laws, right? We're all going to be using AI in our work in some capacity or another, so we need to come up with some way to minimize risk. So the pillars are fairness or effectiveness, right? Having some procedure or standard to ensure that the system, or to try to ensure, is meeting its intended purpose without bias. Competence, having some objective specification of what criteria are required for human developers and operators of AI. Some quality control criteria around the people who are doing this. Transparency, which is quite difficult in the generative AI context, but nonetheless have some ideas that we'll talk about the systems to help generate trust among the objects or the subjects or the targets or the customers, whatever noun you want to use, of the system. And accountability, understanding who is responsible for the operation of the system. That also is important in a contractual context when you're dealing with an AI provider and a customer, having some accountability and some risk allocation, which we'll talk a little bit more about as well. Okay. This is just not, obviously, this is not a one-size-fits-all. Not all pillars need to be of equal strength. Different applications will warrant different types of protections. So how do you go about addressing some of this? So measuring effectiveness, there are multiple ways to think about doing that. You can have single system validation, you can benchmark comparative systems, but what you really need to do when you're trying to design a measure of fairness and effectiveness is keep in mind what your requirements were initially and make sure they still are valid and make sense. Seek input from stakeholders, right? How do you feel the system is meeting the criteria that were identified? And use metrics that are broadly acceptable to the relevant community, whether it's the research community, the commercial community, regulatory community, whatever that community should be, right? It shouldn't be something that's entirely self-designed, because then that creates a level of subjectivity that may not accomplish what you're trying to do. Robust human-level sampling, and this is an obvious point. Bigger data may not be better data, right? The quality of the data really matters, not simply the quantity of the data. So this is just more preaching, but there is both an ethical imperative and a legal imperative to do this, to measure effectiveness. Obviously, from a legal perspective, there will be liability. We will see more and more litigation arising out of the use of AI, and so the better that you can document what you're doing and show that you took steps to try to make sure that it was effective, the better protected you will be. And the absence of legal and regulatory standards, we're going to have case law. judges developing case law. And so you want to show that you've been reasonable, right, and taken steps to try to protect that. And there's an ethical imperative, of course, as well. AI is used and will be used in very significant decisions, and I think all of us have an obligation to try to make sure it's used ethically. And really, that's also a self-interest, because we saw already 55%, according to Monmouth, think AI is going to destroy humanity. That's not a healthy place to be, right? And if we want to gain public trust, then we need to show and actually follow up on what we're saying, that we're developing AI and using it in a responsible way. Competence standards, those will vary from implementation to implementation, depending on the type of AI, obviously, that you're developing. But it can't only be computer programmers, right? If you're in a substantive area, healthcare, whatever it might be, you want subject matter experts that are involved in that development, right? Because it matters how the AI is going to be used. And it's important to avoid groupthink. There needs to be a diversity on the team. And that doesn't mean necessarily only diversity. I mean, it doesn't mean diversity only in the way we think about diversity in terms of race or gender or ethnicity. It means in terms of perspectives and disciplines. AI is a multidisciplinary process. Certainly in the legal profession it is. You have people who are doing AI law who are IP lawyers, who are data privacy lawyers, right? Similarly, in the development community, I think AI needs to be a multidisciplinary process with people coming from different perspectives and points of view. There should be safeguards. So this goes back to the Wharton professor's idea of AI-human interaction, right? You need to think about how humans will pair with AI in operation, and where you should have human oversight and human design in conjunction with the AI, how those two things will work together, and when there might be manual override. Again, it's not going to be the same for every implementation. It really does depend. But that's the kind of thing that you want to document and show that you've thought about, so that if there's later a challenge, you can say, well, we thought about this. Here's how we decided to approach it. Transparency. Transparency obviously builds trust and increases accountability. You've got to consider what kinds of things are you able to be transparent about. Can you describe how your AI reaches decisions? That's not always so easy, right? Especially in the generative AI context. But can you describe what kinds of data went into the training of the model? I'm going to talk more about this concept in a bit, because I think it's a really important one. How can you show your work, right? So that people can get some confidence that this is not some black box, arbitrary, mishmash. They have no idea how it generates what it generates. Consider, as I mentioned, human-led appellate processes, right? Where there is a question about something. Transparency reports, right? Annual reports that say, here's what we did. Here's how our AI has performed, right? Obviously, there's IP to protect. You're not going to disclose your secret sauce, right? Your source code necessarily, depending on how you're developing it. But there are things that you can share, and I think it's important to share, again, to build confidence, to try to turn that public opinion around, to get people to a place where they feel more comfortable and confident in relying on AI. Accountability, right? The main thing I want to talk about here are two things. One is it's important to ensure internal responsibility, right? Somebody's got to be where the buck stops when it comes to the AI system that you're developing and how it's being operated and used. And secondly, contractual provisions addressing risk are going to be more and more a factor in every negotiation that involves the provision of AI-related services, right? Who bears the risk if it turns out the work product is accused of infringing IP, for example? Is it the AI provider or is it the customer, right? That's a question that there's no market for. For those of you involved in contract negotiations, often when you take a position in a contract negotiation, the response from the other side will be, well, that's not market, right? Nobody does that. Well, nobody can say that here with AI because there is no market, right? So these are all greenfield questions that you're going to have to work through, but you want to address when you're up front in the relationship, rather than wait and have them addressed by a court where there's been nothing discussed between the parties. Okay. And so all of that really, I think, boils down to what I like to call an AI impact assessment. Again, I do have a bit of a data protection background, and in data protection regulation, you're required to do a privacy risk assessment or a DPIA, depending on the jurisdiction that you're in, right? Where you basically look at the data that you're collecting, how you're using it, what are the risks posed to privacy, personal data privacy when you're using it, and have steps to address and mitigate those risks. The same thing I think you should think about doing with AI. All those measures that we were just talking about, addressing them in an impact assessment up front, showing a reasoned basis for how you reached your conclusion and documenting that. I'll tell you, in the absence of legislation, we're going to see enforcement action. We already saw all those statements by all those regulatory agencies. That's what they will look for. The FTC typically will look at whether you've behaved reasonably or unreasonably, in addition to whether you were deceptive or abusive, right? A key component of demonstrations of reasonableness is documentation. The FTC is an agency that's primarily led by lawyers. Lawyers like seeing documents. They look for documentation, right? So even if you did it, if it's in your head, it's not going to help you. It's got to be on paper, right? So people can see that you thought through those things. Focus on the narrow. As a general matter, the narrower the objective of the AI, the easier it is to articulate and to measure, right? The broader and the more amorphous, the harder it will be to demonstrate that what you're doing is not resulting in the risks that the government and others are worried about. Build it to perform a function and have it perform that function, right? I have my cute thing. AI is not a philosopher, a political scientist, or a romantic partner. It's performing a function for you, right? And make sure it's performing that function. I mentioned already, consider IP concerns, confidentiality, and privacy. These are all things that should be built into your impact assessment, and also if you're dealing with a third party, into your contractual relationship. I already mentioned human appeal. One thing I really want to talk about here is consider whether the data is fit for purpose. The data set that you're using to train your AI, is it appropriate for what you're trying to do? And Tanit Jabru, who I mentioned before from the DARE project, has proposed something called a data sheet for data sets. And what she means by that is she's proposing that AI systems put together a data sheet, right, that shows lots of essential information about that AI system. And you see the list there. What was the purpose of the data set that you used? Who created or funded it? How many instances does it have? Is it, are there relationships between instances explicit? Are there errors, redundancies, or noise that you had to deal with? Does your data set contain confidential or non-public information? That's clearly going to be relevant from an IP and also data privacy perspective. Does it identify subpopulations? Does it have personal data in it? Sensitive data, which is a subcategory of personal data. Are there export controls associated with the data set? Because that could have implications, right? If the data set includes export control protected information, then there might be a limit on whether a non-US user can use the data set, use the work product of that data set without running afoul of export control laws. Again, hasn't been addressed, right? So having a data sheet allows people then to assess the risk themselves before they use the system. I think it's a great concept. It's not so easy to implement, and in many cases you may not be able to answer all those questions, but I think it's something to think about when you're looking at this issue. And that's it, and I do have, I think, some time for questions. I didn't look over at the cards, so I lost track, but that's okay. So please.
We had a case in Canada where a judge imposed a publication ban because the accused was a young offender. However, he was a notorious kid, and enough people made Google searches with his name and the case that it started to be associated. So in the future, when you Google the case, he came up in the top 10 results. And Google's answer was, we didn't do that. We didn't see that coming. So what do you do with cases like that?
So it's an interesting question. I don't think that's really a question that would be resolved by principles specific to AI, right? That goes more to sort of well-established principles of the First Amendment and free speech, which will vary from jurisdiction to jurisdiction, right? So, for example, I'm sure you know in Europe, Europe has a right to be forgotten. It's a little bit of a misnomer, but the general concept is that, right? And in that situation, it very well could be that Google would be required to take steps to obscure that search result for European users. In the United States, that's not the case. I don't know about Canada.
So you do a carve-out of certain kinds of searches then? And say you can't display those?
So that would be a question for Google. I assume they are able to do that because they are able to take steps like that in Europe.
Okay, thanks.
Hi, I'm Alex. I'm a graduate student at Cal State San Bernardino. I just wanted to know, how do you keep up to date and current with all these new laws and policies and propositions coming out?
Well, the flip answer would be Google, but so it's a great question. So there are public searches, but in addition, there are legal research services that we subscribe to, and also we happen to have a very large AI group, and so we're always looking, for the latest developments, and we share them in the group. It was actually quite frustrating because just this morning I had 3 emails from people in the group about new developments, and I said I can't take any more new developments. I literally just updated the slides last night, but that's those kinds of things.
Thank you.
Jeffrey Carpenter, any comment on how you think e-discovery is going to play out in terms of getting information about details from models?
E-discovery, you mean geared toward trying to
You know,
understand
I'm
how
going
the
to
models
sue
work?
somebody
Yeah,
because
right.
they used AI, and so I'm going to try to, in the discovery process, get information about how it made decisions.
So it's a great question. I think that we'll see the use of AI in e-discovery to try to get more information about AI in litigation, and so it'll be a bit of a cat and mouse. And I also think that, as a general matter, my advice to clients is you assume that everything will be produced if you are sued, right? So any inputs that went into that data model, if they're still in your possession, custody, or control, will be discoverable. What that looks like, we'll have to wait and see.
Hey, I got two. One quick one not so quick. So the quick one is, you mentioned, okay, so an AI, from what I understand, an AI cannot be an inventor on a patent.
Correct.
But what if I use ChatGPT to write a patent and then file it myself?
That's a really good question.
Then I'm the inventor and first to file.
Yes. Every question,
OpenAI did
actually,
file it.
all these questions are good questions. It's unclear. It's unclear how much human input is required. I think that, I don't know, I'm not a patent lawyer, but my suspicion is that if you falsely describe yourself as the inventor, meaning it really was entirely AI generated, that would be a basis subsequently to invalidate the patent if the patent office didn't realize it itself. But I'm not a patent lawyer. There might be patent lawyers in the audience who would be able to answer that more definitively. And then the question also is, what if, it was a joint project, right? That where you had AI assist, right? But you actually substantively contributed, and that's also good. I assume, but I don't know that in that situation you could list yourself as the inventor. But again, that will be a question for a patent lawyer.
All right, I'll email you when our patent attorney finally responds to me. He's usually very fast on that question. He's been sitting on it for a while, so I'm sure it's not. So the other question that I had, or it's more of a comment, is a lot of that stuff you described and that the legislation brings up and yada yada, all this, it works nice if I'm either the developer of it or the product manufacturer or the IT department. But what if I buy a device?
Yeah.
So say this thing is full of AI. While I take a picture of you, there's AI in there. While it's taking the picture, it's doing AI. What's the deal with that? So now, trusted AI, so to say, when I'm on the COTS buyer end, I'm not getting that, whatever that data sheet was, or I don't even know anything about buyers. I don't know nothing about it. So what am I going to do now?
Right. So I think there's a difference between a consumer implementation and a commercial implementation. I don't think that consumers realistically will face liability for uses of AI that are found to be infringing or unlawful, unless they're making a conscious effort to do that, right? If the AI system is set up in a way such that the output that you're using infringes someone's IP, as a consumer, I don't see as a practical matter you having liability. In a commercial context, though, I think that is a significant concern, which is why I mentioned before, it's important to think about those issues before you contract and to try to address them and decide whether you even want to use them. I have a client, for example, that is interested in using AI to help code. It's a gaming company. And I said, well, the real risk that you run here is that you're not going to own the code. And they said, okay, so we'll only use it for code that we don't care about. I said, okay, so that's a decision they made, right? But those are the kinds of calculations that you're going to have to undergo if you're a company looking to be a customer of AI.
Thank you.
I think you kind of just answered my question because I'm a company who's trying to figure out how to talk to my leadership team about what an AI policy looks like. So we're not developing AI, but using it. So I'm just curious if people have found good resources for, right, like explaining it to leadership, which means you have to give a little bit of a high level, like, here's what we're talking about, and then obviously dig into the actual issues. So as a customer, that's a challenge, is discussing it with our leadership, and then as the person who's going to have to review the contracts, like, are there specific things that we should be keeping an eye out for? I'm not a lawyer. I'm sure we'll have a lawyer review it, but they are not going to be as familiar with the concepts around AI. So I'm trying to kind of build that in-between space.
So this is a fast-moving area, and so I'm really not aware of any treatises or anything like that are out there yet, other than the litigation treatise that I mentioned earlier, which is not relevant really to this question. I would say that companies are approaching this, and we're helping companies in this area in two different ways, and they're a little schizophrenic. They have one approach toward the use by their employees of AI, and that generally has been prohibitive, right? Prohibitory, right? In other words, you may not, right? Some companies are thinking about it a little more carefully, but the initial reflexive reaction was, we don't want you to use it because confidentiality concerns, all kinds of issues. You're putting data into ChatGPT, who knows where that's going to go, et cetera. And on the other hand, we want to use it ourselves. Let's figure out how we can use this to make to boost productivity, maximize result, and the kinds of issues you need to think about in the contracts are the kinds of things that I was talking about, right? Whether it's data privacy, IP, confidentiality, all those kinds of things. And those are, we are helping. I mean, I'm not pitching myself, but I and other lawyers in the AI space we're helping advise clients on that now.
Okay.
Which actually, I'm glad you asked that question because I wanted to get back to Niro Rubini, who I mentioned before was ruined my vacation. He talks about how AI is like this terrible mega threat, and I do think it will cause job dislocation and job loss, but I think also it's going to be a tremendous boost to productivity. We're going to see perhaps economic productivity gains that are like what we saw in the 90s. For those of you who remember when the internet really started taking off. And so companies are not going to be able to stay away from it. Everybody's going to be dealing with it in some capacity or another. But
Yeah,
anyway,
that's sort of what we're experiencing
Yeah.
is like this initial, oh God, panic. And then I'm trying to present it as an opportunity, but one that we're thoughtful about, right? We're risk managers here.
Yes.
So yeah, thank you. I probably will reach out. I appreciate it.
Sure.
Yeah, so that goes around my same question around being more specific. Do you have certain templates that you're using for these impact assessments? I've started one with my company, and I'm using some of the questions that you have there that I got.
So it's funny you ask, because I just had a client ask for us to develop one. So not yet, but we're in the process of developing impact assessments. We do have shell policies for employees, for employee use of AI, and as I mentioned, we're in the process of developing impact assessments. This is such a fast-moving field, right, that everybody's trying to catch up.
Yeah. And then the NIST that you referenced, was there a special publication that you?
Yeah, it's if you Google NIST AI risk management framework, I think that'll come up 1.0. Okay. That'll come up. It was I think in March of last year.
Okay, great. Thanks.
Sure. Great. I think one more question.
Yes, I'm Tim Granson. I work for a nondescript government agency, NIST. I didn't work on that, but one point I wanted to stress is the idea of the data sheets is a really good one, and take that metaphor and apply it elsewhere. A lot of the complexity of attacking this technically is pretty daunting, but you can make yourself answer questions. Why did I do this? What were my design objectives? How did I collect the data? Was it signed? I mean, people do this data and then they forget to sign it. And then who knows what it is 5 years later. But take the idea of data sheets and apply that to other elements of it. Ask yourself crucial questions. Why did I do this? What was my design objective? You can get pretty complex about how to do these things, but at different parts of the AI process, ask yourself critical questions. What was my objective? What was I trying to accomplish? What was the purpose for it? Are there other purposes planned? Of course, there are legal issues when you start to document yourself and then you don't do it. That's another complex thing. But think simple things. Document your objectives and what you're trying to accomplish.
That's absolutely right. Yeah, you're 100% correct. And NIST has been very thoughtful in the way that it approaches this, like it did with data privacy. I think that it's a helpful framework to think about the way you're suggesting. Why am I doing this? And what am I doing to address the concerns that come up?
Thank you.
Thank you. Thank you, everybody.